Hi, I'm Charlene Theodore, and I'll be your host for this installment of the OBA Foundation video series dealing with equalization payments. I'm joined today by two family lawyers, Frankie Wood and Eric Sidvari. Welcome. Thanks for coming.
Thanks for having us.
So, Frankie, to start us off, can you let us know what is equalization of net family property?
Equalization of net family property is a product of Ontario's Family Law Act. It's created by and unique to this statute. It does not exist as an independent right. The purpose of equalization is to try to ensure that following the breakdown of a marriage, both spouses equally share in the growth in the value of the property they accumulated during the marriage, regardless of what the property is and who owns it.
That is the intention, but in practice, that is not always what happens. That's because equalization is a one-size-fits-all calculation, with certain rules and certain exemptions to these rules. While both the rules and the exemptions are supposed to make the calculation as fair as possible, there's always going to be extraordinary circumstances in which applying the rules and the exemptions lead to unintended, unfair outcomes.
So, what are the basic rules?
The underlying calculation itself is pretty straightforward. You determine the net worth of spouse one on the very day that the marriage ended and subtract that from their net worth on the very day they got married. This gives spouse one's net family property. You then do the same thing for spouse two and get spouse two's net family property. The spouse with the higher net family property owes the spouse with the lower net family property 1/2 of the difference. That's how you equalize the difference.
Perhaps it's best to show by example. Let's say spouse one had a net worth of $25 on the day that they got married, but this grew to $100 by the time they separated. This makes spouse one's net family property $75. And let's say, in comparison, spouse two had a net worth of $0 on the date of marriage, but their net worth also grew to $100 on the date of separation. Spouse two's net family property is then $100. Therefore, spouse two would owe spouse one an equalization payment of $12.50 because that's half the $25 difference between their net family properties.
This example shows that the basic calculation is relatively straightforward, but also that it can be counterintuitive to what someone might expect. You might say, if both spouses have a net worth of $100 on the day they separate, why would one of them have to pay anything to the other? The answer is because the calculation looks at the overall accumulation of assets between both parties and tries to ensure that this is equally shared, rather than trying to ensure that both parties have the same net worth. Spouse one, who started off at $25, only added $75 to their net worth. Spouse two, who started off at $0, accumulated a full $100. To ensure that both spouses equally share in all growth in either of their names, spouse two pays spouse one $12.50, so they now respectively gained $87.50.
If this seems confusing to you, don't worry, you're not alone. It can take going over a few calculations to appreciate exactly how the calculation works. That is why, if you are separated or you're thinking of separating, it's best to meet with a family law lawyer who can help you go through the calculation and make sure you understand.
You talked about net worth. What is that?
When we talk about net worth in family law, we're talking about adding up the value of all the property and assets owned by a person on a given date, and then subtracting all debts and liabilities that the person owes or that reasonably apply to their assets on the same given date. That gives us that person's net worth on that particular date.
When we talk about property in family law, we are referring to this term in the widest possible sense. Property includes essentially anything that has value. It's not just obvious things such as a home, a bank account, an RSP, etc. It's also less obvious things such as holding shares in a company, owning intellectual property, and even air miles. The same is true with respect to debts. Again, the idea is to be as comprehensive as possible. That is also why it's best to seek the assistance of a lawyer to help you.
Who does this equalization scheme apply to?
It only applies to married people, and then it only applies to them if and when they separate. If you marry and remain married, there's no equalization payment. If you never marry at all, there's also no equalization payment.
Yeah, equalization of net family property truly is a unique set of laws that, for better or worse, only applies to married people. So there still is a distinction between getting married and not getting married, and what legal rights you have or don't have, at least in Ontario.
How is equalization paid?
Equalization is a cash payment. At least it's a cash payment by default. If someone doesn't have the means to pay in cash or the person receiving the payment chooses to accept a non-cash payment, then it can be paid by other means, such as rolling over RRSPs, transferring a house, or dividing a pension, etc. but the default is cash.
When does the equalization payment have to be made?
Technically, it's due and owing on the date that the spouses separate. However, it's possible to delay payment for up to 10 years. It's incredibly rare for this to happen, but it is something the court has the power to do. That said, it's also standard for interest to be included as part of the equalization payment to compensate for any delay in payment.
Thanks. When can you make a claim?
Well, anytime after separation, but there are limitation periods, so you should make sure that you meet with the family law lawyer and find out what is important for you.
What information and documentation do you need when you're meeting with your family law lawyer?
Ideally, you should have a document that confirms the existence of every asset and debt owned or owed on the date of marriage and on the date of separation, as well as confirming the exact value of each of these assets and debts. For example, if you owned a checking bank account with TD Bank on the date of marriage and still owned it on the date of separation, ideally you should be able to produce a copy of your account statement for the very day that you got married that shows the exact bank account balance on that date, and then be able to do the same for the very day that you separated. If you can do this for every single asset and debt on both the days, the calculation should be relatively straightforward and uncontroversial.
Are there any reasons why you would not have such documentation for every piece of property?
Well, if you didn't make and keep copies of documents covering your date of marriage and you were married for a long time, it's very possible that copies of this documentation no longer exist. Banks are only required to keep records going back 7 years. In the digital age, banks sometimes do have records going back longer than that, but they may not. You may very well run into a situation where you know you had an account on the date of marriage, but you're unable to provide proof of its existence or proof of the exact value of that account on the very day that you got married.
In addition, there are assets or debts that can be difficult to accurately value. An easy example of this is if you own a company. There are several different ways to value a company. For example, you could value it based on its liquidation value, i.e. the amount of cash that you'd be left with if you liquidated all of its assets and paid off all of its debts. But you also might say that that is not the appropriate way to value a company, and instead you could use a multiple of the annual income the company earns as a correct approximation of what the company is worth. Both approaches can be correct, and both may come up with different values. It just depends on the individual company, and even then, there might still be disagreement over what the best and most accurate valuation is. Either way, lawyers can often assist in writing letters and making inquiries on your behalf to try to collect as many documents as possible and help you through deciding how to value.
So how do you value a matrimonial home?
That can be a tricky question. The easiest answer is to put it up for sale on the open market and see what it sells for. However, that's not always available. Some people want to keep their home and not sell it. Other times, the value you're seeking to determine is not the current value, it's the value the home was either on the date of marriage or on the date of separation, which may be sometime in the past. Either of which may already be far enough in the past that the current value is not the same. In that case, if an agreed on value cannot be arrived at, you may need to hire a certified property appraiser to provide an expert opinion of value after looking at the home, as well as what comparable homes sold for in the relevant time period in order to provide an expert valuation. This can be expensive and controversial, with different experts coming up with different values.
What other issues should people be aware of when calculating equalization payments?
Well, I think one of the biggest things that people often overlook or fail to consider are contingent disposition costs. Just because you own an asset and can confirm its current gross value doesn't mean that there are not inherent taxes or other costs of realizing that value that should be considered to truly arrive at a person's net family property. As indicated by the very title, the idea is determining a person's net value rather than their gross value. So realistic taxes and other costs should be included in the calculation. This includes such things as factoring in capital gains tax owed on an investment property, as well as determining the likely future income tax liability related to a person's RRSPs. This whole exercise can get pretty complicated the more complicated and diversified a person's property becomes. It's also an area in which meeting with a family law lawyer is very helpful.
You need to be careful of certain types of property that the legislation says are to be dealt with in accordance with special rules. This includes property that the legislation has determined should be excluded entirely from the calculation, such as gifts or inheritance received during the marriage, as well as the very special treatment of any matrimonial home. The exceptions to the general rule, especially with respect to matrimonial homes, are really something that you need to be careful with and things that people are often not aware of unless and until they speak with a family law lawyer.
You talked about matrimonial homes having special treatment. What is considered a matrimonial home?
A matrimonial home is any home that's ordinarily occupied by a married couple at the time they separate. It doesn't matter who owns the home. Title can be held in one person's name or in both persons' joint names, or even owned by someone else, such as when the married couple is renting. What matters is whether or not the couple is living in the property on a regular basis around the time that they actually separate. There's no limit to the number of properties that can be deemed to be matrimonial homes. A married couple can have 1, 2, 6, or 16 matrimonial homes. The married couple also doesn't have to be living every day in the property for it to be considered a matrimonial home, so long as they ordinarily occupy it with some regularity. Therefore, cottages, ski chalets, hunting lodges can all be considered matrimonial homes along with the married couple's main home. It really is a designation that encompasses a wide range of properties.
What is the special treatment that matrimonial homes receive?
Unlike any other piece of property that is included in the equalization payment calculation, you do not get to include the date of marriage value of any matrimonial home if that home still exists on the date of separation. This effectively means that you don't get a date of marriage deduction for bringing a matrimonial home into marriage, and instead, the entire value of the home is shared in the equalization payment calculation rather than just the increase in value during the marriage itself. Other special treatments on the matrimonial home include that you can't change the locks and lock the other spouse out of the home because both spouses have what are called possessory rights to the matrimonial home. And as well, you can't encumber, transfer, or otherwise dispose of a matrimonial home without the other spouse's written consent.
Are there general misconceptions that you frequently come across?
Yes. Many people believe that equalization means that each asset gets divided individually, that you split your matrimonial home in two with each spouse receiving 50% of the total, and then you move on to your bank account and split that in two, and then split your RRSPs equally, et cetera, et cetera. It's very common for people to think that that's what equalization means, but that's not how property division works in Ontario. Again, it's a calculation of overall value with one spouse paying the other spouse a cash payment to equalize the difference in value. We don't split each property in two.
People often think that there is commonality of property for married people, that if one person owns a piece of property, both of them do. That just isn't the case. There's no communal matrimonial property in Ontario. If you hold a piece of property solely in your name, it is presumably your property, and the default property division scheme is that it will remain your sole property. It is only the value of the property on the very day that you separated, as it compares to the value on the very day that you got married, that you include in the equalization calculation and share. The actual property itself, though, is presumably yours and yours alone, with your spouse having no ownership or other rights to it.
Are people able to opt out of equalizing their property?
The most effective way to opt out of an equalization payment is through a domestic contract, such as a marriage contract, which is what we call prenups in Ontario. In such a contract, there are lots of things you can do to opt out or vary equalization payments, such as predetermining the value or values of difficult-to-value property, agreeing to exclude certain property from the calculation, or opting out entirely and agreeing that both spouses will keep their property completely separate and apart from the other following any separation or divorce. If you are planning on getting married and worried about how equalization would impact you following any separation, it is a good idea to go see a lawyer and find out what options are available for marriage contracts, including whether or not your concerns are already addressed by the legislation or if you could really benefit from having a marriage contract in place.
I wish we had more time to keep discussing these issues, but I would like to thank both of you, Frankie and Eric, for providing this very helpful information, and thank you for your time.
Very welcome.
Thank you.